the proceedings this morning, help us to understand the presentations and to use that understanding to guide our deliberations on this important bill. We ask you to keep all those who are still intending to attend this meeting safe, although they're not attending in person, but to speed them to their devices to join the meeting so that we can have full participation and the outcome may be in line with your will and with the interests of the people of Jamaica. Amen.
Thank you very much, Senator Bunting. Apologies for absence. I have apologies from Member Floyd Green, Member Robert Morgan, and Member Hugh Graham. So can you note those apologies for me, please? In relation to the welcome and opening remarks, just some housekeeping matters. It was agreed at the last meeting that a notice would have been placed in the Observer and the Gleaner on April 25th, 2021, advising of the 2-week extension to May 5th for the persons to make submissions on the legislation. We have received a total of 4 submissions so far. That would be Mocha and the private sector, the Office of the DPP, the Ministry of National Security. So as a result, we will be taking Mocha and PSOJ today. We will, at the end of this meeting, decide on new dates, proposed dates, and we'll get to that further on down the agenda. In relation to the reading and the confirmation of the minutes held on the 21st of April, I would ask, or I would have hoped that everybody would have read the minutes. There is an extensive there's an extensive summary of the presentation made by MSET at the last meeting. And I ask if they are for confirmation of the minutes by those 2 persons who were at the meeting of the 21st. And then we can move to matters arising from the minutes. Can I have a reading and confirmation if there's no corrections or any amendments to the minutes of the 21st of April, 2021?
So move, Mr. Chairman. Good morning.
All right, can I have a second?
Second, Chair.
Thank you very much. Who was that?
Cavan Gill.
Morning, Senator.
Morning, how you doing?
Morning. So in relation to matters arising from the minutes, is there any matters arising from the minutes that anybody would like to raise at this time? Seems that the minutes are being captured in a way that's satisfactory to members. Very, very, very unlikely that that minutes, there's no matters arising. So that's very good. So, ladies and gentlemen, colleagues, we want to move straight into the presentations this morning. We want to welcome the representatives from the Major Organized Crime and Anti-Corruption Agency, Mocha, and also the private sector. We will move in that order, and I would ask that the presenters just introduce themselves and their teams and move right into the presentations. So at this time, I would welcome the first presenter, which is Mocha.
Good morning, Chair. Good morning, committee members, colleagues. My name is Nigel Park. With me is Lieutenant Colonel Patrick Cole, DSP RF Dunkley, and Inspector Patrick Linton. So I'll move directly to the presentation. The preamble, which covers the entirety of page 1 and goes over into page 2, is really setting the stage. We are just making the point that we are now at the time where technology is being utilized by criminals to their great advantage. And we're setting the stage for rethinking of how computers are viewed in our legislation. They need to be recognized more directly as being instrumentalities which are involved in the commission of offenses rather than just devices that are there for our use. Our first comment on page 2 is with regard to a widening of the definition of damage, which is found in the section 2 definition section. The way damage is defined there, it's in the context of only being capable of occurring in relation to an impairment of a computer or to the integrity or availability of data. When you look at that definition in the context of a section 9 offense, for example, which is the use of a computer for malicious communication, the way that offense is framed, the communication, it appears that it intends to try and capture is communication which is likely to be libelous or slanderous in nature. So the harm that is likely to occur to a victim of such an offense would not be in the context of an impairment to a computer or with regard to an impairment to the integrity of data or the availability of data. So we are coming into the committee that they consider an expansion of the so that it is capable of encapsulating different types or categories of damage that can result from a particular cybercrime. I don't know, Chair, if you wish me to proceed to the next point.
Sure. Go right ahead, and I'd ask members to just note their questions so that we can take questions or contributions at the end.
We have no difficulty taking questions at the end of each point, if that is more convenient for the discussion, sir.
Wait, what do you prefer in terms of the flow of your presentation? You prefer to do it at the end, or you prefer to raise it as you finish the particular point?
It might be more convenient to raise it as we finish the point, but I wouldn't want to lose the dynamism of the discussion. So we are convenient with whichever approach, sir.
Members, any suggestions?
Chair, may I recommend that they proceed with the presentation? We will just take notes because we don't want to interrupt their flow. We'll just take the notes and then ask questions accordingly or seek clarifications accordingly.
That was my thought. Thank you very much.
Very well. Our next comment is with regard to Section 8. Section 8 deals with computer-related fraud or forgery. The way this offense is framed, it is essentially trying to treat with the manipulation of data to effect a fraud. Now, we are operating in a time where criminals are utilizing technology. Something we have seen quite frequently is where persons who are effecting forgeries, for example, are utilizing computers to effect the forgeries. So I would hasten to add that our Forgery Act was passed in 1942. The last amendment was made in 1985. Nowhere in the Forgery Act is there mention of the word computer. So there's clearly a lacuna in the legislation as it relates to dealing with forgeries in the paradigm of computers. In the second paragraph under section 8, that's on page 3, we make the point where we are suggesting the introduction of an offense or a category of offenses that treat on creation and reproduction of electronic copies of forged documents. Because what you will find is you may conduct an operation, take someone in custody who is alleged to be a forger, for example. When an examination is done of their device, maybe a computer or a tablet, whatever it is, you may see documents in various stages of production, which, if completed and printed, are capable of appearing to be genuine. Now, some of the documents that we believe should be beneficiaries of this type of protection are educational and professional examination results, birth, marriage, death certificates, decrees absolute. Passports already received some type of protection. If a passport is covered under the Forgery Act, but it doesn't speak to an electronic version in a stage of production. Also, monetary instruments, driver's license, motor vehicle documentation. The list that we've provided in the legislation is not intended to be exhaustive, but just to give an indication of the types of documents that we feel ought to be covered under such a provision. And we also commend that a companion to this revision, if it's accepted, is that the Forgery Act be updated accordingly so that it can marry in with what these improvements will mean. For example, the Forgery Act is quite limited in the items for which the possession without excuse is criminalized. And again, it's a function of the time when it was passed, 1940s. Section 9, next point on page 3, treats with the use of a computer for malicious communication. Now, as contemplated in the legislation, these types of communications will be more or less slanderous or libelous in nature. But the way the offense is created, you have some conjunctive elements that the communication needs to be obscene, constitute a threat, or be menacing in nature, as well as be done with the intention to harass or cause a person harm or the apprehension of harm. Now, when you look at more modern formulations of this type of offense, and we've cited section 14 from the Barbadian Computer Misuse Act of 2005, the first distinction that is seen as it relates to our offense is that they've made these elements disjunctive. Therefore, satisfying just one is capable of proving. They've introduced an element of recklessness in the conduct of the sender as it relates to the annoyance, inconvenience, distress, or anxiety that sender caused to the recipient or intended recipient of the communication. We commend that one factor that be added is the embarrassment it may cause. And we're also commending to the committee that the subject of the communication be included as an aggrieved party who is capable of being a complainant. At the top of page 4, we wish to commend for the committee's consideration the inclusion of hate speech as a type of communication that is deserving of some punitive treatment. And by hate speech, we are really focusing on racial slurs and commentary of that nature. The next paragraph, we are looking at—
Chairman, could I just ask a question? I heard the definition, you said racial slurs. How far does hate speeches go? I mean, does it, if I make a derogatory comment about somebody's sexuality, would that be considered hate speech? I just want to be clear so that we don't blur the boundaries of what may be considered an offensive term versus what is hate. So I don't know if you have a full definition of what you would categorize beyond that example of what is hate.
Well, thank you for your question, Member Robinson. The examples or the definitions of hate speech that you will find tend to be pretty exhaustive and expansive and would include the example that you gave. We are not suggesting that it be as expansive as to include that, but what we are saying is that there needs to be an alignment of the values that we place and the types of communication that we think ought to be permissible and ought not to be permissible. And in truth, what we're really is proposing something for the consideration of the committee. It's a matter of the committee, for the committee rather, to make a determination as to how wide it should go or whether or not we want to go there at all.
All right, okay. All right, I think when we get there, we can look at it because while I may understand your concern, I don't want, it can become subjective about what is considered hate, and you could be going into the realm where what you consider to be something offensive or hate, I don't, and then we're criminalizing it. So I just have a little caution about how we define that. All right?
Yes, understood, sir. So there is another category of malicious communication which the Act does not currently treat with. Now, in the cyber lexicon, the term malicious communication does include types of malware. As currently drafted, Section 9 predominantly appears to treat with communication that is likely to be libelous in nature. So we are suggesting to committee that they examine whether the identification of malware as a type of malicious communication should be stated explicitly, or whether they wish to treat with malware as a category of malicious communication in a bespoke provision by itself. And if you revisit the point we made earlier about the sort of restrictive definition of damage, you can understand from a contextual perspective, or better understand from a contextual perspective where we're coming from with this particular recommendation. We are also commending a widening of the category of protected computers, which is captured in Section 11.2, where we are suggesting that explicit reference be made to the computers or servers which are concerned with the public revenue, as well as critical infrastructure systems. Examples of those could be computer systems that manage our water supply systems, or those that control the electricity grid. There may be systems which are in plants, certain chemical plants, and different type of manufacturing processes which are capable of being hacked and manipulated. Section 16. Section 16 contains at provision 1B Roman numeral 2, the inclusion under the power to seize, the power to render data inaccessible, or to remove data from a computer. But when you look at the entirety of Part 3, which provides the investigative tools under the legislation, there is no mechanism outlined that law enforcement can use to seek to legitimately render data inaccessible or remove it from a device. So currently you have a scenario where, say somebody is charged for a lottery scamming offense. You seize a device from them, and on the device, for example, you may find lead lists. Now, in the event of that person's acquittal of the offense charged, they are entitled to the return of their device. Currently, there's no mechanism by which law enforcement can permanently remove that data from the device. And we are seeking that this power be provided because it's counterintuitive. Stop the commission of an offense, and for whatever reason the acquittal occurs, you return the device and you return your subject with the tools for which they can recommence their offending. We acknowledge that under Section 20, there is a provision for forfeiture of computer material, and based on the definition of computer material, it is capable of including a computer. However, that authority has been reserved to the DPP, and we are recommending that an extension or a widening of the category of prosecutors capable of making such an application include clerks of the court and other prosecutors who may be operated by way of fiat from the learning director. So we're about to go to suggested offenses and other considerations at the foot of page 5. Now there are a category of devices: skimmers, card readers, magnetic stripe cards, extracted credit card bins, as well as point of sale machines that we are commending to the committee that the possession of them be criminalized without lawful excuse. Section 10 of the Cybercrimes Act potentially includes some of these devices. However, the possession of the device needs to be in the context of the commission or facilitating the commission of another offense under the legislation. And we are commending that the possession of these items be a possession simpliciter offense, as against the possession being dependent on the occurrence of another offense for it to be made out. On page 6, number 2, we are commending the creation of a general possession simpliciter offense as it relates to the unauthorized possession of a computer program or data by an individual. And under number 3, we are commending for the committee's consideration two offenses which currently exist under the Law Reform Fraudulent Transactions Special Provisions Act of 2013, namely being the Section 5 offense, which penalizes the owner, occupier, or person responsible for the management of a premises who knowingly causes or permits said premises to be used for the commission of offenses under the Act. And Section 15, it allows the court to have consideration of the fact that an accused person is unable to properly account for property which is disproportionate to their known sources of income. The next item being, we have a commentary here on the general ransomware threat. And in the course of our research, well, first we'll make the point that the incidence of ransomware being affected is on the rise. Even within this week, there was the incidence of the shutdown of a major pipeline in the United States. And we have all, are aware of the implications of that event. Now, in the course of our research, we came across an entity called the Institute for Security and Technology, which is a non-partisan, non-profit network. And essentially, it has amongst its membership companies such as Amazon, Microsoft, and also has in its membership the FBI and the United Kingdom's National Crime Agency. And they established a ransomware task force, which is essentially a global coalition of technology companies and law enforcement bodies with the core objective of helping countries, industries to better combat ransomware attacks. They published in April of this year a comprehensive framework entitled Comprehensive Framework for Action, Key Recommendations for Ransomware Task Force. And that document contains approximately 50 recommendations under the broad headings of deterring ransomware attacks, disrupting the ransomware business model, helping organizations to prepare, and responding to ransomware attacks more effectively. And it might come out in the course of the discussion that consideration of this document might be better done outside of the deliberations of this committee, but we thought it prudent that our attention, a copy of the document was made available for the consideration of the members. And we just, I'm sorry, we just feel that the document provides an opportunity here that perhaps from it we can distill certain basic foundational things that can be introduced through the amended Cybercrimes Act, which will then provide a foundation for us to treat more adequately with ransomware and other type of malware threats. Through pages, well, it starts at the foot of page 7 through page 8, 9, and onto page 10, we've created a table of different cyber crimes together with generally accepted definitions of what they are, which we are also commending for the committee to consider. And that in the round is our presentation.
Thank you very much. Thank you very much. For good order, I would just ask if you members to raise their hand, and I'll acknowledge them and allow for them to just name the particular section that they are raising and the inputs from there. So if you can raise your hands, I will start to acknowledge immediately. I'll start with Member Robinson, Julian, you wanted to expand on anything you were saying earlier?
No, I mean, just, I would love to just see the definition of what is considered hate, because we have a boundary that we have to be careful about how far we go, that we don't infringe on free speech and criminalize speech. So I just, in the detail, I just want to see what is considered hate.
All right. Is there any members that want to make comments on the Mocha presentation?
Yes, Minister. My hand was up, but I'm not sure if you're able
Yeah,
to see.
just seen it now. Perfect. Go ahead.
Right. So I wanted to first commend Mocha for that comprehensive presentation. I was able to do some reading. And one of the things that I found concerning was the similar concern that Member Robinson raised on the matter of hate speech. I wasn't able to see it being clearly outlined in Section 9. I'm not sure if I'm the only one missing where that is located, but I also wanted some clarification, maybe from the technical team, about what that would entail. And even if it would go as far as encouraging suicide, because in some jurisdictions, that is a cybercrime. So I wanted to know what would be the boundaries of that kind of language that they would constitute as hate speech. I also had another concern with the use of the word obscene. I know that in some sects, obscene is generally associated with something of a sexual nature. I wanted to know perhaps if that is the definition that we might be taking on. And maybe this is not specifically to Mocha, but more so to the technical team. And to Mocha, I wanted to know if you had any suggestions for what this section should be expanded to give a better understanding of what obscene really entails.
Okay, there is a United Nations Strategy and Plan of Action on Hate Speech document, which is available on the internet. And what it says is that there is no international legal definition of hate speech, but the term hate speech is understood to include any kind of communication in speech, writing, or behavior that attacks or uses pejorative or discriminatory language with reference to a person or a group of persons on the basis of who they are, in other words, based on their religion, ethnicity, nationality, race, color, descent, gender, or identity factor. As I had indicated earlier, we fully appreciate that this issue is capable of being a very slippery slope, and we would not wish to be viewed as trying to restrict persons' freedom of speech. But when you look at international standards or what is happening in legislation of this type, there is a recognition that certain types of communication are not permissible, they are not condoned, and it's merely a suggestion that we consider whether, as a nation, Jamaica is in a position where, we are ready to make such a step. So it's really as a discussion point for us to ventilate and see if we are yet at that place in terms of, the maturity of our people and how we seek to engage with each other, as well as the signal that we send internationally as to where Jamaica's values are. As it relates to the definition of what is obscene, in our local legislation, the definition of obscenity has always taken on a sexual dimension where it's suggestive of sexual activity, and we would not be seeking to depart from that interpretation. And if I could just segue immediately in terms of how we envision the Revamp Section 9 offense, what it would look like. You would have the offense as it currently is, with the different components being disjunctive, whereby if someone's complaint is that a communication about them or that they've received is obscene in nature, then that would be sufficient in terms of providing the ingredients required to prove the offense. So by making it disjunctive, you would allow for a wider category of offenses to be captured. The second component of the offense as we view it would that there be some sort of treatment of malicious communication specific to types of malware in a very bespoke way. As to how that provision looks, that is something that, I mean, in the course of the discussion, the technical team could come up with different formulations, but certainly we would be willing to participate in those discussions as ultimately we would be one of the users of the end product. So we do have a vested interest in what it looks like and what it seeks to capture.
Thank you very much for that. Does that clarify your point? I got kicked off for a few minutes, so I don't know who was that responding to? Who are you responding to? Was that Senator Morris still?
Yes,
Yes,
it was me, Chair. I have a better understanding now. Thanks for that.
You're welcome.
Great.
Chair.
Is there anybody? Yeah, who is that?
Yes, Chair. Cavan.
Yes.
Clause 8 of the Act that says a person commits an offense if that person fraudulently with intent to procure any damage for himself or another person. And I want to, I'm specifically speaking to B, where it says access any computer inputs, alters, deletes, or suppresses any data. And you had indicated that you would have wanted, or you were making a recommendation to have an inclusion of copy, if they were to have copied data, or duplication as an insertion to this clause, correct?
No, sir, not a copy of data. We were recommending that you create a category of offenses that deal with the possession, creation, and reproduction of electronic copies of documents.
Okay, so it would be another insertion as opposed to what is contained in B.
Yes, sir.
Okay, thanks. The other question that I wanted to ask you, I'm trying to recall if it was in relation to clause 16, the computer material, where you may have indicated that if there was an acquittal, you still wanted to delete the contents of the material, if there was an acquittal?
Yes, sir.
Why would that be so if there was an acquittal? I'm just trying to understand.
Well, the acquittal might not be connected with whether the material on the computer is capable of committing an offense. It would be, if you can think even further in the context of whether if the person was not authorized to be in possession of such data. Our view is that it's counterintuitive to allow the person to leave with the material.
So, I see what you're saying. So
yes,
if you were able to identify other potential risk you would want to delete?
No, having identified that there's a risk in
Yes.
returning the device to the person with the material on it, then law enforcement should be properly authorized and allowed to remove that data.
Okay, I now understand. And the last thing I wanted to ask, you had made a list of some devices, pointer sales. What was that list? Again, just remind me for my record.
Skimmers or card readers.
Yes.
So a skimmer is a device that it can read the data from the magnetic strip on the reverse of debit and credit cards. That data can be then used to clone the cards and they can be utilized.
Yeah.
You have the magnetic cards themselves. That would be the card that that data is then placed on, which would allow it to be used. The credit card bins, those, I will ask Mr. Linton to give you the technical term around that, but if I could just complete the point of sale machines, in the last, maybe a couple months ago, there were some videos on social media that showed persons going to business places and they replaced point of sale machines with those that they took. And part of the utility, well, what is really happening is that when those point of sale machines are used, the monies do not go to the business. Also, they can use the point of sale machines to reverse the transactions. And when you reverse the transaction, you can direct the money to any account that you choose.
That you desire.
That you desire. So what we are saying is that without lawful excuse, persons ought not to be in possession of these items.
Okay.
Mr. Linton can explain what extracted credit card bins are.
Yeah, hello? Yes, good morning. So generally the data on the magnetic stripe or strips are being stored as binary information. Track 1, track 2, track 3. Track 1 has information that is enough to make a purchase. So somebody can extract that data from your magnetic stripe and use it to make a purchase online. You can also extract track 2 or track 3 with discretionary data to be able to reproduce a card. So generally when somebody told you that they clone a card and then encode the content on a new card, this data is also being sold online, darknet, in hacking forums, or even on devices that we have seen in Jamaica. So they sell these devices for, depending on the kind of card, whether it's a gold card, it might be 200 US, it might be a platinum card for 300 US. So that data can then be bought and used to reproduce a new card. So that's what they refer to as the bins, because it's really binary information.
So what you're saying to the committee, therefore, is that you'd want an inclusion in the legislation for those persons who would have been unauthorized of having these types of devices in their possession.
Yes, sir. And the data.
And the data.
Yes, of course.
And would that be a standalone clause, or do you wish to insert it as an addition to clause 10?
I believe, sir, that a standalone clause might be neater because it would allow it to be considered separate from
separate.
Yes,
all right. Yeah, thank you. Thank you, Chair. Thank you very much. Sorry, you had something else to say, Mr. Linton?
Yes, I was explaining something to you. So while some of the information that is found, that is skimmed from the cards, can also be considered as personal identity information, because you'll have what they call discretionary information, your name, your address, that. Sometimes you don't see names, you just see the numbers, those binary numbers that can be used to reproduce cards. So it's important to understand it in both ways.
And so they can always reproduce a card using the binary numbers and affix a name to it?
Yes, of course.
Okay.
Yeah.
Thank you. Thank you very much, Chair.
Thank you, member. Thank you. Any other input in relation to the Mocha presentation?
Yes, Mr. Chairman.
Go ahead, Member Bunting.
The couple points. The recommendation regarding the possession simplicity of information. Is the Mocha team suggesting an offense that would be sort of similar to the Law Reform Fraudulent Transactions Special Provisions Act offense of possession of identity information, which just possession in the absence of having a legitimate explanation of why you would have that would be an offense?
The law reform offense, I recall, requires the possession, requires the officer to satisfy a particular context in relation to the possession. So it is not a possession simplicity offense, as is generally understood, for example, with illegal possession of firearm, which is a analogy that I think everybody is familiar with. You either have a license to possess the firearm or you don't. So we are looking more towards something similar to the illegal possession of firearm type possession simplicity offense. So in the absence of a lawful excuse, then possession is illegal.
But that's my recollection of the anti-lottery scam law. If you were in possession of a lead list, whether on your computer or in a physical, physical printout, and which had the identity information of multiple people, and you could not explain what legitimate purpose you had for having these lead lists in your possession, then you were deemed to have committed an offense.
No, member. There's a bit more to that offense. What it requires, I mean, I can locate the section and read it out, but what I recall is that the wording says that the officer needs to form a reasonable inference that the identity information has either been used. Okay, I can read it to you directly now, sir. It's section 10. A person commits an offense where that person knowingly obtains or possesses identity information of another person in circumstances which give rise to a reasonable inference that it used or is intended to be used to commit an offense. And this offense was drafted in this particular way because in the hotel industry, for the telemarketing sector, there were persons who would be in possession of what would qualify as identity information, but they would be able to provide a lawful excuse as to why they had it. And so they needed to create a distinction between the person who has it for us and those who obtain it or possess it with the intention of committing an offense. And the insertion of the part about the reasonable inference, that would require the police officer to look at the circumstances of the find. What were the reactions of the person when they were apprehended? Were they able to give a lawful reason for being in possession of the data?
So I understand now. So what you're saying is that that is not the type of wording you are seeking in this case. You are more seeking the possession simplicity in the Firearms Act.
Yes, sir.
Illegal possession of firearm. Okay, that's one. The second point had to do with the hate speech. in the law that's commonly called the Anti-Gang Act, I forget the technical name for it. I think it was some law reform suppression of criminal organizations act, something to that effect. They had come up with a specific formulation that spoke to advocating violence, speech or communication or song or any works that advocated violence against an individual or group of individuals. You may want to look at that formulation, which was, move from the broad hate speech, which might just cover pejorative terms, to specifically advocating violence against, and see whether that might be a more appropriately narrow definition to be put in any bill. And the third point had to coming back to those. Unfortunately, I'm doing this from my cell phone, and with limitations of screen, it's hard to go back to your written presentation. But where you were talking about the conjunctive versus the disjunctive elements,
yes, sir.
To prove the offense. It would seem to me there that we need to pay. I take your point, and I think we should even look beyond the just making them disjunctive, but look if they are sufficient and sufficiently broad, because this area, I think, is one that is most commonly abused in today's circumstances, and which is likely to become more prevalent. So I take the point, but I'm even thinking we may need to, and without having the actual presentation in front of me, but I think you should even look at maybe adding additional subclauses that would say, for example, something that, I know there's the one that deals with harassment, but something that attacks a person's reputation in a really vicious way. The chairman would understand what I'm talking about. And these people seem to feel that they can do it because it's in this cyberspace, things that they would not risk doing in outside that virtual world. They feel they can do it with abandon in cyberspace, and I don't think they should be allowed to get away scot-free.
Agreed, sir.
Thank you, Mr. Chairman.
Member Bunting, my 100%, and I think it's an area that needs to be looked into, that are suffering from that and with little or no recourse. And the fact of the matter is that even the method of recourse takes so long in the judicial system. But I think when the DPP makes their presentation, I'd like to get into that in terms of the swiftness of justice, because it's all well and good that we go through and do all of the timely hearing of these matters. Then obviously we won't have achieved what we're setting out to do. But I support you 100% on that, and I think the entire committee would be supportive of that and sympathetic. Is there any other member that has anything they'd like to contribute in relation to the Mocha presentation?
No, Minister Miles, but just to acknowledge, just to put on the record the appreciation and the support for the recommendations made in the presentation from the Ministry of National Security.
Yes, I see a presentation from MNS itself, Member Sabuda.
Yes, Chairman, because we do, it's a all of ministry concerned. So, you know, we've sought to ensure that everybody and all of the agencies and arms of the ministry get to opine and share their views on the legislation before us.
Absolutely, very important, especially with the role that your ministry and the agencies under it play. So let me just thank Mocha for a very comprehensive input, and we will definitely take on board some of the suggestions that have been made by you in committee. And of course, if needs be, we will have further consultations as we conclude in this matter. So thank you very much. And we to PSOJ. Mr. Chris Record. I think Mr. Chris Record is leading PSOJ. You can introduce your team, and of course, Mocha, you're more than welcome to remain and lead if you so desire. Go ahead, Mr. Record.
Thank you, Chairman. Good morning, ladies and gentlemen. Thanks for having PSOJ here make its submission. We have a very small and agile team here with us this morning. Ladies before gentlemen, Stacey Hines is president of the Jamaica Technology and Digital Alliance, which is part of the PSOJ. She's a member of the PSOJ, and of course, she's also a member of the PSOJ's Innovation and Digital Transformation Committee. The Digital Alliance is the former Jamaica Computer Society merged with an organization called JITSA, which represents all the IT businesses, well, most of the IT businesses in Jamaica. JITSA is termed in Jamaica Information Technology and Services Alliance. Also with us this morning, who will actually be speaking on our behalf, is Attorney at Law Chukwuemeka Cameron, also a data privacy advocate, and runs his own organization called Design Privacy. And so without any further delay, over to Chuck, who will start us off, and then Stacey, who will close for us. Chuck, over to you.
Thank you very much, Chairman and Chris. So the PSOJ in general has a very specific interest. We acknowledge that we are living in the information age, and it is critical that we have a safe environment to operate business and grow business using online tools and participating in the internet. So that is our general position. So we do want to see, in essence, a very robust legislation that members, entrepreneurs, business persons can feel comfortable and safe that they can operate in this space. And two, if they operate in this space and there is some criminal activity, that there can be some recourse. We have taken a very practical approach, because in the same manner in which you want to see a society free from crime, because we're now living in the information age, we want to see a cyberspace that is, we can never say free from crime, but there are adequate controls and remedy in place that if such something does occur, we are in a position to seek recourse. So with that in mind, I'm going to start our presentation by just commenting on some of the issues that Mocha raised, because we do have similar concerns. The first concern is as it relates to the definition of well, from section 2, subsection 1, subsection C, how damage is defined and viewed under the legislation. And we definitely adopt the position of Mocha on this issue, in that we do want to see a widening of the definition and we have been more specific to say we wanted to make reference to mental distress. And that touches and concerns the issues that we heard raised by most of the members, that if there is some sort of cyber incident or sharing of communication that impacts negatively on an individual, that individual does not necessarily have to prove any physical or actual damage to some device or computer. Having the ability to prove mental distress or anguish or some other similar language should be sufficient to ground a criminal action. But we still want to, we still maintain the point that mental distress or emotional distress must still be proved. And that can easily be proved by some medical examination. So that's the first issue. Our general concern and a lot of the issues that we have raised speak to the criminalization of innocent actors or innocent acts. And in today's economy, where we have to drive our economy to be innovative, to leverage data, leverage internet resources. We need an environment where young persons getting into the IT space are not fearful of touching a computer or being creative and experimenting and breaking stuff, because you are required to break stuff and that's a term that is actually used. So we do appreciate that there's a balance in terms of what is willful breaking, what is accessing something willfully, as opposed to an environment that engenders and supports young IT entrepreneurs, or that caucus of young persons that are necessary for the growth of our economy. So that is a general context of our concern. The extent to which, one, young IT entrepreneurs, two, IT professionals who are carrying out their day-to-day operations, and three, innocent persons that are just using the internet that happen upon certain destinations on the internet. And by virtue of the language of some of the legislation as it is, it does criminalize those acts and would then cause them to be possibly faced with a criminal charge and then prove their innocence. So if we were to look specifically at section 2, subsection 2, as it now reads, it says, for the purposes of this act, a person obtains access to any program or data held in a computer if the person causes a computer to perform any function that, and then it lists it out. And this definition does ground section 3 of the act that sets out what the criminal offenses are. But we're specifically concerned with, when we look at the language, a person obtains access to any person or program or data held in a computer if the person causes a computer to perform any function that. And if any of us were to access any website or any internet-based resource, your computer would automatically cause a copy of that person's content to be replicated for you to view it and for you to access it. So without having any unlawful intent or malicious intent, by just accessing a website, you are copying your computer to enable you to access the data or view the data. You are actually causing a copy of it. So as we set out there, is that the danger is that an innocent actor who finds a vulnerability may be found to have caused a computer to perform a function unwittingly. So Mr. Record often shares an example where he's better to tell the story before I accuse him of any criminal offense. You can impute yourself, Sir Chris.
Oh, it was just an example of us searching for data, and Google presents a link to a book, and you get the book, you look at look at the data in there, and only to go to the official provider of the official writer of the book to find out that the book was actually being sold. but the Google search engine actually found a link to download the book for free. You had no idea because many people offer their books for free for you to download. So who's actually committing the crime? Is it you or is it Google?
So the issue in that scenario is that Chris ended up on the back end behind that that retailer's paywall. So he would have been actually viewed to have been trespassing. And by just viewing, and this was just by typing in something in a search engine, and he ended up on the inside of someone's virtual property, and he had visibility of their content without him doing anything. By just viewing that content, he would have been setting himself up to fall prey to this section of the legislation. So we do want to, while we are not recommending this, well, we are recommending that we include language as set out under the remedy, the insertion of any function that willfully and knowingly initiates a specific activity, because the computer does perform certain functions to allow you to perform your normal innocent actions. So just to protect against any criminalization of a criminal act, we do want the state to prove that there was a willful and knowing initiation of some computer function. So if we were to go on to section 2, subsection 4C, it states he's not acting pursuant to a power or function given to him under this act or the Interception of Communication Act, and the word unauthorized shall be construed accordingly. And we are suggesting that consideration needs to be provided in this section for any ethical hacking framework. So again, we are now in a new paradigm. GCERT would agree, Mocha would agree, all our security services would agree that we will never have sufficient resources to protect our digital assets and infrastructure. One, because the government, private sector owns and operates most of our national infrastructure. And two, our resources will always be limited. So there is a role in this ecosystem for ethical hacking. And this is where we're really leveraging the power of the crowd. So this is what we do actually be calling crowdsourcing. If we were to look at it from a commercial context, Microsoft was always a closed ecosystem. BlackBerry was a closed proprietary ecosystem. BlackBerry is now in the trucking business, I understand, having that proprietary closed system having failed. Today, Microsoft has totally transformed themselves, and they offer one of what is considered a low-code environment, and they are now the proponents of open source for the most part. And that is with all the resources they had. They decided that with all the resources we have, we cannot build killer products by ourselves. We must rely on the external development community and find out a way to integrate them into the development of our products. And that's what they're able to do. We are commending that the legislation needs to acknowledge the role specifically of an ethical hacker, because that is what they act as force multipliers. It is a very dangerous road to go down, and we acknowledge, because one can easily say, well, I'm an ethical hacker once caught in a nefarious or a position that one ought not to be in. And so a lot of thought and work has to be put into how that is developed. And the PSOJ, along with the Digital Alliance, is prepared to really sit down and see how such a framework can be developed. There has already been initial discussions between the different organizations and the university to see how such a framework can be developed. And when we think about our educational institutions, we are teaching cybercrime at our universities, but the extent to which our students who are being trained in this area can actively do tests in the market is non-existent by virtue of the criminalization of this section. Chris, can you scroll down? So if I may direct your attention to section 3, subsection 1, a person who knowingly obtains for himself or another person any unauthorized access to a program or any data held in a computer commits an offense. So this actually goes back to this goes back to section 2, subsection 2, where we spoke about the definition of how we define access. So access in this context doesn't simply mean getting access to somebody's computer. It means getting access to the computer and causing something to happen. That is how it's defined in subsection 2. And we're saying that causing something to happen must be willful. And so the recommendation in this instance is that the clause would read, a person who knowingly obtains for himself or another person any unauthorized access as defined in section 2, subsection 2, to any person or data held in a computer commits an offense. Section 4, subsection 3A. So I have made reference already to this whole concept of.
Chairman, if I can ask for clarifying.
Yes, sir.
I thought when you were starting the point, you said that allowances should be made for ethical hackers.
Yes, sir.
That can actually provide a public service by accessing or exposing vulnerabilities in our infrastructure or in the software that runs our national infrastructure. But I'm not sure. I mean, knowingly obtains, I mean, would still not cover that situation because the hacker might deliberately obtain. But to me, it seems to turn on whether it is used for some malicious purpose or for commercial profit or some reason like that. It either sabotages the computer or the software system. It exposes private data publicly. It uses that data for some commercial purpose, for some benefit to the person who obtains it. But if none of that takes place, you are still saying if they knowingly do it, that it should be criminalized, and therefore won't that have the exact chilling effect on ethical hackers that you seem to think we shouldn't, that Minister Samuda wants to investigate those persons and criminalize them.
So you have captured the substance of our concern.
Chuck, if I may,
Sir.
because I don't want member Bunting to
just leave some things outside the off stump, just leave them alone.
No, but as my colleague and friend, I wouldn't want it to descend to becoming a reporter of disrepute. No one has ever said that. What we have said clearly is that certainly any breach of Jamaican law, whether cybercrime or otherwise, any minister, any officer in the government would be duty bound to report it, and that goes where it may, regardless of what that refers to. No one has ever, and I think important to note for the record, no one has ever threatened the prosecution of a reporter making something public. That has never been said, and no public record exists of that. You've had erroneous reports of such, which is a matter for a different day. But having declared it a wide ball, I will.
I'm giving you the opportunity to clear up your position, so I'm happy that I've been helpful in that regard.
Well, anyone who had listened to the interview, which was live, would be clear on the position. Those who seek to make mischief have had their fun. But thank you for that. Thank you for that wide ball. We'll take the one run.
But that wide ball that is made reference to has really brought this issue to the fore. And when an examination of section 2, subsection 2, speaks to how easily a good actor, by going on a website, can be said or found to be conducting a criminal action. So our general position is that as the legislation is now structured, there is no provision or acknowledgement of the fact that there are good actors, and we can use those good actors as force multipliers to protect our national infrastructure. So
and
that is
in principle, though, Mr. Cameron, if I may throw you, Chair, but I think your provision or your recommendation of including mental distress, despite the numerous definitions online and from varying medical journals, I think that would have to be expanded to be very direct in terms of what we clear from that, because a good actor, as you classify, is a force multiplier and something that we'd have to consider. However, a good actor could also cause mental distress, depending on what they proceed to do. So you may have protected them with one addition, as you've recommended here, but you may have also criminalized them at the beginning in terms of Act 2C. I think that would have to, if mental distress is going to be included because of good actors, or mental distress is going to be included because of the anguish and the particular pain that an incident can cause, then more thought would have to be given to how that is defined, and then beyond that, how we define a good actor. Because the problem with ethics and morality in law is, I think the boundaries have to be very clearly defined. And I don't know in the text space, and I leave that to yourself, and I'll take guidance certainly from the team like Mocha and MNS and CERT, etc., in terms of what is reasonable for the definition of those boundaries. I don't know that it can be left to interpretation, because my interpretation and yours and probably everyone on the call will likely be different, because to my mind, I take the point of force multiplier because we need it in every aspect of law enforcement. But to go back to 2.1c and that recommendation, you've just put them back behind bars.
I'm mindful. And we raised that issue of definitions as the last issue. And what we do need is, and it's a very delicate balance to strike, because you cannot over legislate and say, make a definition A, B, C, D, because we do understand if we are so specific and you don't put everything in there, you leave out some things. And on the other end, it cannot be too wide and left at the arbitrary discretion of a state agent. So what we are recommending as a halfway house is really, as it relates to internet and computer-based suspected criminal activities, that we either have a special tribunal to treat with some of these issues, or two, we have a specialized court. And remember, if we look at this in a historical context, the biggest threat facing our national security back when the gun court was created was gun violence. Unfortunately, that hasn't necessarily changed. but we have an equal and looming threat as it relates to our cybersecurity. And if it is, we acknowledge that that is a serious threat. We do need to not only put legislation in place, but as you heard the chairman say, he raised the issue of the timely enforcement of these issues. So we do need either a specialized judges specially trained in this area, or specialized tribunals that can serve as a filter. So the same way that you have a diversion program for youth, the same way you have a specialized family court that understands family disputes, we do need to have our general courts, and our general courts are not equipped to make a determination whether Christopher Record, who is updating a patch for his client and deletes and/or modifies his client's information and causes him pain and distress, whether or not he had criminal intent to do so. So everybody has raised all the issues and that we have to contend with. So that is why we're of the view that a special court or a preliminary tribunal to resolve these IT issues, not to determine the question of morality and ethics, because our view is you can't legislate for that. But as you can see in our last recommendation, if we're really going to be judging, making morality calls and ethics calls, a judge ought not to be able to do that. The police ought not to be able to do that. And as burdensome as it sounds, only your peers in the form of a jury can do that. Because what we can consider to be obscene today, or what any international body considers obscene, we may not share that view. So the only way we can really effectively, without over legislation and killing our hands, is we speak about trial by jury to determine those issues of obscenity. But just going back to the fundamental issue, to address all of these nuances, to allow IT professionals, IT entrepreneurs to be able to have a free space within which to operate while still being able to be held accountable by the law. We are strongly recommending this body or specialized training for judges, because everything that Mocha said, while they are going in the opposite direction that we want to go in terms of creating a more friendly environment, encouraging people to get involved in IT and the cyberspace. Because once as it is now, having done this presentation with the Alliance, the concerns of their members who are professionals, who are educated, is that they are not even comfortable doing their jobs without getting an abundance of documentation. Because in doing your job, you break things unwittingly. So it is our objective or desire that we can create an enabling society, an enabling digital society, a digital space, while ensuring that it is robust enough to let us feel comfortable that if something is done, it will be treated with. If we may just comment on some of the specific issues raised by Mocha. There, and some of the members, this question of the malicious communication and the impact it can have on third parties. And reference was often made to slanderous and libelous. While me as an individual, and maybe even PSOJ as an entity, appreciates the danger that the danger that faces us with, we have to be mindful of that commission that was held some maybe 10 or 8 years ago. I think it was headed by just Queen's Counsel Small, that looked at defamation and one of the findings that came out of that commission was that defamation should be decriminalized. Flowing from that commission, defamation was actually decriminalized because there was a Libel and Slander Act that criminalized this concept of defamation, and that was repealed. If not the legislation, that section that made it a criminal offense. So if it is, we were to now bring in, if it is, we were to now say that if you commit libel or slander on the internet, you can now be faced with criminal prosecution. We will be going against what society's position now is. And we are suggesting that society's position was reflected in that commission, that extensive commission that was done when we're looking to reform our defamation laws. So we have to.
Mr.
Yes,
Cameron, you
yes,
have
sir.
to know that these positions evolve and circumstances and environment cause what might have once been thought of as obscene to no longer be obscene. And just as easily, some commission that sat a decade ago, when these cyber offenses were much less prevalent, may not have come to the same conclusion today if they were sitting. So, but let me just ask you though, even though it decriminalized libel and slander, doesn't it, if the victim or the target, I'm not sure what's the right word, the defendant in such a civil case gets an injunction, gets injunctive relief against the perpetrator, and they continue, would they not be subject to some kind of contempt of court or something that would, is it that the victim would just have to continue to suffer, particularly if the perpetrator was someone of straw, that there was no effective civil relief?
So that is a very real life scenario that you have painted. And you are always, and the court, so just to share with the committee, the court is very reluctant to grant and issue an injunction as it relates to a defamatory comment. However, the court has been known to do so where you can establish on the face of it, there is serious damage that can be suffered by the words that have been suffered. And this is as a result of a publication on social media. And yes, there is contempt proceedings that are available. So with that in mind, if it is you're saying that there are sufficient remedies in place to address that, we would agree with you and adopt that position. But first, to go to a criminal position, especially when we're speaking about that freedom of expression, and all rights must be balanced. But in order to effectively balance that right, let it go before a neutral arbiter. And that neutral arbiter in this instance should be that civil court and not a criminal court. If it is, you now demonstrate that you really have malicious intent, you can feel the full force of the penal side of the civil law through contempt proceedings. And the court has been minded to go down that road. And in my former practice as a litigator, we have been able to invoke the court to exercise that sort of authority. So yes, it may not, it takes it away, or it takes it outside of the police going into somebody's house because you posted something on internet and locking them up in jail until you can get bail before you can go to a court. Because that's what the impact of this legislation means. That's the impact of criminalizing malicious communication, that the police, having seen something on social media, and they make a decision that and they get a complaint from a third party, that this man is saying that I'm a gunman, that I'm a murderer, and this is not true, and this is putting my life at risk. He then makes a complaint to the police. The police then goes into somebody's house, takes them out of their bed, and locks them up in jail until they can appear before a judge. When in fact, it may be true. He may be able to prove that. So there is recourse available through the civil court. The civil court can issue injunctive relief, and if it is his intent is malicious, there can be sanctions. The final issue, because
sorry, Mr. Cameron, just bear with me a little bit. I just want to. So again, I take Member Bunton's comments. I'm supportive of them. It may be because both of us have suffered the brunt of it in our political careers, while we are finding mutual ground. But the question I want to ask you is, so where is the deterrent? This matter here from, as Member Bunton said, from whenever that USMAR-led committee or whatever it was looked at this to now, today, is a completely different picture. And it is becoming worse by the day because of the fact that persons are not being held to book. And therefore it has become rampant. It's almost a norm, depending on the season and depending on what the objective of the person is at a particular time. But whereas I hear you in Jamaica, civil means nothing. Civil actions are things that your kids and grandkids will be the beneficiaries of because of the court time. And in general, Jamaican people, civil is like nothing. Criminal gets their attention. And the fact of the matter is, if we're really serious about stemming what's going on as it relates to these breaches, then we have to do something, and we have to show that it is something meaningful while respecting due process and rights and all of that. But I'm still not clear in relation to the balance that we're trying to find between those two things. The civil doesn't impress me at all, must tell you.
Let me share with you two examples. So there was one when the curfews were first implemented, and there was this individual who, after the lockdown was implemented, went on streaming live and made reference to the Prime Minister and said, ABC, see, we are outside, me and my friend am outside, and you can't do it, nothing. And then he used some indecent language and made all sorts of aspersions. Are we saying, or do we want a position where, because they used indecent and defamatory language against a member of parliament or an upstanding citizen of Jamaica, that police can go and lock them up for expressing themselves in their expressive language? Because that is what we're seeing. To look at the second scenario.
Sorry, brother Cameron. So yes, why use the example of a member of parliament or a big man, as we call it in Jamaica?
No, I went on upstanding citizen of Jamaica. I also included an upstanding citizen of Jamaica.
The bottom line is it goes across the board, and the bottom line is that since that incident took place, there were certain actions that were taken. And if you notice, it has had the desired result, including an apology, etc., etc. So what I'm trying to say to you is that people respond to action. And the bottom line, if that action was not taken in the way it was taken, you would have those comments being posted every day since the start of the curfew, because everybody is feeling the same frustration that gentleman was feeling. when he expressed himself wrongly.
But they were able to rely on legislation.
Before you come in, Mr. Cameron, I think there needs to be a distinction between somebody saying, boy, my MP is a dunce and a jackass, and maybe even using two bad words to describe him. But it's another completely different thing to say, my MP is a murderer, or my MP is, some really, someone who commits some really noxious criminal offense. To me, there must be a line that can be drawn between free speech expressing, even in very colorful terms, your disapproval or dislike of somebody. But when you come to know, accuse them of specific things that could very well put their own lives at risk, put their careers at risk, put their income at risk, then I think there must be a clear distinction drawn there.
So our judicial system does work. So I did have a situation where an individual was accused of being a murderer, and we were able to go to the Supreme Court, get injunctive relief. Of course, as member of ours, as the chairman has said, people ignore the civil court. What is that? But 2 days or 3 days, him not having observed the injunction and taken down the offensive material, we were able to get a contempt proceedings, and it brought everything to an end. So the court systems do provide and recognize the value of the dignity.
But Mr. Cameron.
Sorry, Peter. Sorry, Member Bunting, just before I forget. So what you're saying, Mr. Cameron, is basically, after I have been wronged, I must now go and spend an inordinate amount of money to go through the process of retaining lawyers to go to court to get an injunction against that particular person, rather than me having to spend nothing and the police taking the necessary actions based on their own investigation.
Mr. Chairman, that's the precise point I was going to make. I can see how the lawyers... But
it's the first time you and I have ever agreed on so many times. But let me just say very clearly, everybody knows that this is like the most ironic thing that I could be cheering this because the bottom line is I've had 30 odd years of it non-stop. So I've wrote the book, and guess what? In all of those 30 odd years, I've been successful in one case, and that case was in the United States of America, not even in Jamaica. And it's not for the lack of trying. I've had lawyers, I can't even tell you how many lawyers I've had and how much I've paid, and got nowhere locally. Only success has been in the United States of America, and those who have a little memory will know exactly the case that I'm speaking about and how it evolved out of exactly what we're speaking about now. And don't ask about the cost, because before you even speak to the lawyer, you have to pay them a retainer. How many people of no means or small means can pursue this course based on the fact that it has a massive cost attached to it?
That was my point, Mr. Chairman. I can understand how the present recourse available is one that is very lucrative for lawyers who practice in the civil courts. I am aware of a case, not me personally, but of a case where just to reach the stage of injunctive relief is well over $1 million in legal fees. You have to get, the offensive material forensically preserved, etc., etc. And it really puts an unreasonable burden on an average person, even a person above average means, to sustain the sort of court action required. And as I said, at the end of the day, it's not like they're going to get any satisfaction because usually the perpetrators, you know, are persons of straw who there's no chance of getting back their costs or recovering their costs. So I hear Mr. Cameron, but I disagree with him entirely.
I don't want us to take over the proceed because of our personal experiences and the emotions that we have about it. But just to say that I agree 100%. And just to close, Mr. Cameron, by saying that after I was successful in the United States, to this day, I never received $1 because they use the court system over there and maneuvered until, unfortunately, death did us part. So I understand perfectly. And this to me is not about me, and it's not about Member Bunting or whoever else is on this committee. It's about the small people who experience this every day and either don't know how to or don't have the means to. And it happens, and it is happening it is now almost the norm. And as a committee, we have the responsibility to make sure that when these proposals are put and we conclude and sign off, that we would have a real good framework going forward. And if we do that, I think that we would have met our mandate. But it has to be that people can get fair and quick responses right through to the justice system.
Thank you very much, members. So the PSOJ is 100% aligned with, as I said, securing that, guaranteeing that safe space against all type of malicious action. What we would suggest or would want this committee to consider then is, while it may be stated as a criminal offense, what then is that accused criminal exposed to? Because it ought not to be that someone that is accused of maligning someone's character be dragged out of his house and put in jail and then have to apply for bail, when the reality is he is assumed innocent until proven guilty.
So wouldn't that be part of the police remit in terms of their investigation and their investigative skills, that prior to taking such an action, that they would have done the necessary investigation to satisfy them that this is something that should be pursued criminally?
So on both, I've had the opportunity to exercise both in the practice, both in the civil and criminal side. It is not, our police force have an enormous amount of work, and they will never have enough resources to do the type of investigations that they have to do given the society in which we operate. But it's not uncommon for police to respond to situations and take actions before the completion of an investigation. And we have to, so the thinking is, and it is within the power of this committee, at the end of the day, we can say this offense does not attract any custodial sanction. So the executive arm in terms of the police would have no remit whatsoever to lock someone up, even to, so the issue of the deprivation of one's freedoms comes into issue. So that is a sort of consideration. While it may be criminalized, no type of custodial sanction or penalty ought to be attached to this infringement or this breach. So that's the consideration.
So then, what is to deter them? That's where I'm a bit lost.
So
what is to deter these people who continue to do this every day, all day nowadays, for different motives and purposes. What is it that will make them think twice?
Well,
from pressing the button.
All these people must be considered to be innocent. All of these people will have to also hire an attorney to defend them if their actions are innocent.
Yeah, but how does this differ from any other criminal offense? I mean, don't the police investigators have a responsibility to at least see that there is a prima facie case before they would go to arrest someone who is accused of this offense? I mean, I'm assuming that there's the DPP, for example, has a manual, I forget what it's called, like a prosecutor.
Decision to prosecute.
Yes, and therefore police investigators, I imagine, will be guided by that and not just capriciously go out and arrest persons on a complaint without doing their own investigations. So I will accept, Mr. Cameron, that notwithstanding all these responsibilities, officers may, notwithstanding that, go out and behave inappropriately or improperly or preemptively in doing these things. But to me, it's really no different from somebody being accused, a complainant come in and say, this person stole my goat, or a fridge from my house or whatever. The police would then have to go and do their own investigations to satisfy themselves that there is a solid case, a real case against this person. So I'm not sure how it differs from any other criminal offense or any other criminal complaint. And coming back to the chairman's point, if it was a criminal offense but without without a custodial penalty, then, and this I'm asking for some clarity here, then let us say there was a range, they could be fined $1 million, up to $1 million or up to $5 million, whatever the case may be. In the absence of their paying that fine, would the custodial sentence still be available?
Yeah, so yes, there is I don't remember the name of the legislation, but a debtor's law. And there is a debtor's law that if you don't pay a judgment, you spend time in jail. So that it does follow.
Mr. Cameron.
Yes, sir.
Go ahead, finish your point.
In this instance, where we're going to be restricting their right to movement and their right to expression, it is necessary for the legislation to specifically identify what that language is that would attract criminal penalties, especially in circumstances where you are touching and concerning those fundamental rights. So it cannot be left to the discretion of an arresting officer. He must be able to say, look, when you look at this schedule, you use this word and said this about this person, that is a criminal offense. So if it is, the committee is looking that direction, the legislators, you have a duty to be very specific with your legislation if it is you are going to be restricting their right to freedom of movement and their right to freedom of expression. It cannot be left at the arbitrary discretion of even a complete investigation. The legislation has a duty to protect those fundamental rights while balancing the integrity and dignity of normal citizens from abuse.
So Mr. Cameron, just to be clear, so basically, you are saying that if I am wronged or I feel I am wronged, that I should be the one that has to now retain a lawyer and seek through the courts an injunction or whatever it is that the lawyer recommends. So I consider myself to be the victim. And in order to protect who is deemed as the person who is the aggressor, that the onus is on me because we need to respect his rights? in relation to how we move in an investigation based on a report that I have made to the police that this person has said X, Y, and Z, and it is untrue. Where I don't understand, where's the balance? Because the bottom line is we come back to the same thing that Member Bunton and I mentioned before. That's onerous at the best of times, both in terms of monetarily and time consuming. It's not that I'm guaranteed to get some reprieve in short order.
So that is the position of the commission, where this parliament actively repealed the Libel and Slander Act in the face of social media. But if it's the next step then must be in acknowledging that times have now changed, and this parliament is moved to put some remedy in place for something that has now become rampant. In doing so, how you can balance while protecting that person that has been maligned, you have a duty to recognize those fundamental rights, and how you do so is by specifically setting out, creating a schedule that identifies what those offensive words are that can attract criminal sanction. Because the danger is that while one person may be attacked or maligned, the entire population is exposed to the arbitrary exercise of discretion of any enforcement agency, arm of the government. So accepting the real societal issue that has been raised, and that I'm very much aware of, we are very, very much aware of, and it will affect members of our association as well, in no uncertain terms. However, so if it is, we are going to put some, tighten the language or the legislation to afford and recognize that it must be done in a manner that recognizes their fundamental. They have a right to one, presumption of innocence, because not because you have made a complaint means that the state can deprive them of their right to freedom of movement and their right to freedom of expression. So if you are going to do so, it ought to be done in a very specific and narrow manner.
I agree 100%, but bear in mind that the duty of the citizen, if he feels that he has been wronged, is to make a report. He has no control after the report is made based on the investigation or the investigation process. And therefore, I take your point that it has to be very clear, but there has to be sanctions. If there's no sanctions or if it's felt that the system will be against them in terms of time and expense, then we won't get much out of it. So I take your point very clearly, that it has to be in keeping with people's rights, but there has to be a balance in terms of how and what the sanctions are and how we respect the rights during that process.
Thank you very much, sir.
Thank you very much.
As it relates to clause 10 that was commented on, where items are being criminalized if they are in possession of certain items without lawful explanation. Again, from the PSOJ point of view, we acknowledge that we are living in the information age. We acknowledge that not everybody follows the formal business procedures in terms of registering with registrar of companies, obtaining NIS, paying all the statutory duties. Are we saying that unless by criminalizing being in possession of certain implements, we are saying if you are not registered with the registrar of companies and have in your possession certain items, you are guilty of a criminal offense without more. And I don't think that is, I do think that recommendation has to be thought through, because the question must be, what is a lawful excuse and how is that established? Because in the absence of that expansion, we're saying the only thing you can reasonably look at and say, is this a registered business person? And if that is the threshold, we're saying, okay, if you are not a registered business person and you're engaging in any type of commercial activity using this type of equipment, you are guilty of a criminal offense. So we do want to be mindful of what the government's agenda is in terms of creating an environment that promotes innovation and that leverages technology. So we are of the view that the focus must be on the intention and the actions of the actors and not the tools that are being used, because every tool can be used for good or bad. So to be in possession and to address the issue as it relates to Section 16, the police having authority to remove data from an individual's device, having the court having found them guilty, innocent of the charges. On what basis then can the police force make a unilateral determination that they have the power to restrict the citizen's right to property? That goes contrary to our democracy and what the courts are there for. If it is, the police officers want to apply to the court to say, Madam or my lord, we recognize that you have acquitted this person, but we have come to the conclusion that this material is either offensive or can be used to commit some other harm. We are asking for an order to destroy or access this information, but it cannot be that a court has found a citizen of Jamaica innocent of the charges that the police would have investigated, brought before the court make a determination, and then the police outside of the courthouse infringe and restricts their constitutional rights. That one, and I'm not I guess how it was shared may have been the challenge, but the appropriate thing, if that is a real concern, that the legislation be amended to give the court the power to make that order. But it cannot be the other way around, where the legislation gives the police the power to contravene or restrict our right to own property. And there has been a lot of discussion around the hate speech. You see where, well, all the members are rightly concerned with that language. And I think the recommendation, well, the direction that Member Bunting was directed, I think can really address that real issue that was raised. As it relates to Section 9 or the Section 8 that deals with the criminalizing fraudulent activity, we do want to be proactive, and instead of over criminalizing actions, the government has the power to facilitate or enable the use of technology such as fingerprinting technology. We have an Electronic Transaction Act that speaks to digital signatures. We have the E-Apostille Act that was, and that may not be the specific name, but this was legislation passed last year, ushered through by the Minister of Justice, that recognizes the reception of digital documentations.
E-Apostille was a convention.
Thank you very much, sir. So we have recognized that. We have now ushered that into our local law since last year. Let us recognize the underlying technology that would give effect. Sir Chris let us recognize that technology that would give effect to the E-Apostille, because that is how we really protect the underlying integrity of documents. So there are more active, proactive steps that the government can take that can more foster this innovative environment that the PSOJ is interested in in creating instead of further criminalizing and stifling innovation. The final issue, and I may have said final before, but this is a final issue as it relates to the infrastructure and the Colonial Pipeline event. So we have a question. We don't necessarily have a position because it only recently happened. And so even the fulsomeness of the question may be left up to question. But the question is, if it is, there were to be an attack on our critical digital infrastructure, would the government of the day have the ability to call a state of emergency based on a cyber event that does have that type of far-reaching impact? And if the answer to that question is no, what legislation or language should properly deal with such an issue? Because the thinking is, if there were to be such a report that one of our national or critical assets were attacked, it is brought to the attention of the Minister of Defense. He would then have to go to his Attorney General. When the Attorney General is analyzing, hey, so this is a cyber attack. How can this equate to a national emergency or national disaster? Is there any legislation or language or entity that could take a preliminary step and say this attack equates to a national emergency, which can then provide the Minister of Defense the requisite tools for him to make a decision as how best to treat with it? Because we fear, and I think we would be aligning with Mocha and all the security forces that the cyber warfare and cyber attack is one of the major threats facing our economy, as was demonstrated in America. So we want, as a PSOJ, we want to ensure that the government has all the available tools to protect itself and its citizens, and a cyber attack not be relegated to some computers went down. Flowing from that, when we're speaking about protecting our digital infrastructure, because Section 11 does speak to that, and we don't necessarily agree with Mocha with specifying the specific national assets, because we think the legislation, that language is wide enough to contemplate everything that they said. And the danger is with legislation, if it is you begin to specify everything and you leave out one, one can easily argue and apply the rules of interpretation and say, look, they stated 10 of them, number 11 wasn't there, so it was never contemplated, as opposed to leaving it wide, giving the relevant ministry or authority sufficient latitude to determine that that is a critical asset. So bearing in mind that the private sector owns and operates the majority of our infrastructure, and any cybersecurity strategy, and Section 11 does form part of that cybersecurity strategy. Why aren't we not leveraging existing legislation to harden national digital infrastructure that's operated by business operators? And when I'm referring to the Data Protection Act, that requires and mandates that basic cybersecurity or information security controls be put in place. In the absence of that, we don't have to worry about a state actor attacking our infrastructure. In the absence of any basic digital information security, any individual can threaten our national or critical infrastructure. So one recommendation is, we are fortunate enough to have legislation, and America doesn't have this legislation available to them. We already have a national legislation that requires that all data controllers implement basic IT security. It may be far from sufficient, but it does plant one firm block to build that upon which we can build a national strategy. You have been very indulgent, and we're very grateful for the opportunity to participate. We do, as our position is, we do want a robust legislation that we feel comfortable to participate in. So when we are maligned and attacked, we don't have to find an attorney to protect our good name. So we are aligned. And we do also acknowledge, though, that it is we are in the information age, and we have to focus on how can we drive innovation and create a space where people are free to participate. Unless there are any questions, I would really turn it over to Stacey, but we are here to answer any questions, please.
I would just say, with respect to one of your closing comments about the state of emergency, I would remind you, and I know you probably know this section better than I do, but the Governor General can make a proclamation declaring a state of emergency if he's satisfied that action has been taken or is immediately threatened by any person or body of persons of such a nature and on so extensive a scale as to be likely to endanger the public safety or to deprive the community or any substantial portion of the community of supplies or services essential to life. It seems to me that is certainly broad enough to allow a state of emergency to be declared if there was an attack on our national infrastructure that would have, prevented the Water Commission from operating effectively, or the JPS, or the telephone and the data providers, etc. So I think the Constitution, as it currently exists, does have enough breadth that would allow the cabinet to go to the Governor General and seek to get a state of emergency declared in those circumstances.
And that member Bunton is an expert on state of emergency. So when he gives it that advice, it is very sound advice based on his
only when it suits him, Chair.
In this case, he's supporting Member Gill. He's supporting the possibility of a state of emergency. That's good different.
Thank you very much, folks. I think we have completed our points, and I just ask member of my committee, Stacey Hines, to just wrap up with any last, I guess we can call it the capstone comments. Go ahead, Stacey.
Thank you, Chris, and thank you, Chair. Just to say that we want to share that we unequivocally support the Act, both through the private sector and through the Alliance. And in particular, we want to ensure that we are, as Chuck may have said a couple of times, enabling a thriving environment for innovation and also for experimentation, because that's what technology is all about. That is what has created a lot of the things that have solved many problems, both locally and globally. In particular, when we talk about ethical hacking and building out a framework that supports this space of testing and experimentation, we also want to make sure that we're looking at it from the perspective of security research, because that is something that we'll have to have happening increasingly. And the students, professionals, as well as organizations that are a part of the private sector and the Alliance will want to feel that they are safe in conducting such types of experimentation. And to speak very briefly to the suggestion of the tribunal, which is something that we actually discussed quite a bit while we were examining the Act, we could look at the telecoms tribunal that exists and think about the possibility of expanding this to include things that are related to the wider context of ICT. So I think that Chuck has made quite a significant number of points around really having the frameworks and specific context in place to guide the legislation so that those of us who are operating from the professional perspective, whether it's an individual or a technology company, are also being considered when the laws are being put forward. So we'll open up for questions beyond that, but we'd like to thank the committee for listening and for your positive feedback.
Chairman, may I? Chairman?
I suspect you can proceed.
All right, I will look at you as the standing chairman then.
Well,
Member Samud. I want to start. Yeah, I want to start by making a few observations. Listening to both presentations this morning, the matrix that is going to be developed from these submissions are going to be very critical for this committee because of the varying types of submissions that have been put forward. And it is a situation where we are looking at a legislation that is seeking, on the one hand, to create protection against the onerous attack on cybercrime. But on the other hand, we have to treat with the proposed amendments in securing also the protection of enhancing business operation, and clinical research. Now, the PSOJ, I can just very well imagine that its members would have looked at this and to see how can we operate in a space where there's a high investment now in terms of migrating operations on a digital platform that calls for research, calls for your own customers. I can think of the banking industry that has created investment in migrating its customers and clients towards a digital platform, and how there is that protection now, an enhancement for its members. My members in the union have raised some concerns with me, and Chuck, I can look at the clause 5.1 about the unauthorized modification and think of the programmers who are tasked with designing and creating software programs and integrate systems and maintaining operating systems, and how the view of just unauthorized modification can expose them to criminal actions. Yeah? And I believe strongly that we may have to examine tightening up that particular clause with words like knowingly and intently and purposely, rather than just how it is left there in order to protect someone who may have been conducting research, creating cutting edge, making modifications that were never contemplated in the beginning. So I'm very, that part of it attracted me in terms of making a representation in supporting your submission. Now, I share the same sentiments of the chairman and member Bunting around this attack on individuals, where social media now gives that opportunity with the click of a button to make malicious statements against individuals. And I'm very concerned about it being going to proceedings of a civil nature, because I'm strongly of the view that there ought to be a very strong deterrent against these types of actions. Ms. Hines, I heard the representation around the tribunal, and the more we advance into a digital platform, where as we're speaking now, the world continues to change digitally, we may very well have to examine what that tribunal will look like, how it can operate in the scheme of things. It might not be part and parcel of the existing legislation, but certainly we have to prepare for it. And I would ask the PSOJ in sharing with us as members of the committee what that tribunal, what a particular tribunal may look like for us to examine. So Chairman, those would have been my comments in regards to the presentation made.
Thank you very much, Member Gill. Interesting comments. Is there anybody else, any other members that would like to make any input on the PSOJ's presentation? If so, just right ahead.
The Chairman, I'd really just like you to allow me to, on behalf of the committee, thank both presentations, thank the presenters for both groups this morning, both Mocha and PSOJ. I must say this committee has enjoyed a very high quality set of presentations thus far. And I think they've been well researched, very useful. And I look forward to the points that they make informing our legislation and moving us towards a stronger piece of legislation.
Hello? Hello? Hello?
Yes, yes, who's that, Mr. Linton?
Yes, sir.
Go right ahead, sir.
I have a few things that I just want to, just touch briefly with Mr. Cameron. Mr. Cameron, are you there?
Yes, I am, sir.
Yes, sir. So we were looking at the ethical hacker, and I don't know if you were actually using it in that context interchangeably with a security researcher who actually has within the course of his duty happened upon vulnerabilities. Sorry, happen upon. Oh, sorry. Let me just turn on my video. Yeah. So I don't know if we were actually looking at a security researcher, cybersecurity researcher, who was happened upon during the course of his duty or vulnerabilities without exploiting them, but actually report them. Like a bug bounty program, that kind of thing, as against an ethical hacker who. The whole term hacker is anybody who was trained to circumvent a security system. Now, an ethical hacker is somebody who's employed and has actually signed an agreement, right? So that's what makes it ethical. You get permission to do a job, whether penetration testing or vulnerability assessment. So I think you were more talking about a security researcher who sees flaws, needs protection because you don't want him to go around reporting the stuff, and then law enforcement grabs him to say, how is it that you found this out, that kind of thing. So I realize that a lot of persons tend to use the terms differently. A security researcher can be an ethical hacker, but it's when he gets the permission to do so. Because you don't want somebody, are you seeing? You don't want somebody to circumvent a security flaw and then present himself as an ethical hacker, when in truth and in fact, he got no permission to act.
Thank you very much for that opportunity to clarify. So we are really speaking up to a security researcher, that in terms of a specific definition, we're speaking to that security researcher, sir. All right.
Thank you. Grateful, sir. Mr. Voss, that's the extent, Minister, of my intervention.
Thank you very much, Mr. Linton. As usual, very Good input. Is there anybody, any other member that would want to make any comments on the PSOJ's presentation? You can go ahead immediately right now. All right. So it seems as if we have had discourse on the board's presentations. Before I go to any other business and then set the dates for the next meeting, just to say to members, especially new members of the newly elected members or appointed members, that of course all of this will be noted by the ministry, and of course all of this will be reviewed, and of course as a committee we will meet to discuss all of the presentations and of course the inputs from the ministry and of course our final inputs. So it is again 2 very good presentations, starting with the ministry's overview at the last meeting. Today has been a longer meeting than usual, but necessary. And I can't emphasize the importance of this legislation and what this will mean for our future and of course generations to come, because as we know, technology is only growing and digitization. So it's important that whatever we do here has the impact that we need it to have in order to make sure and streamline the usage of technology. So with those few words, I want to thank everybody, and especially the presenters and of course all the supporting staff outside that are supporting the committee from the various ministries, agencies, and of course the Attorney General's department. The proposed dates for the next meeting that the House has given me is Thursday, June the 3rd at 2 p.m. and Tuesday the 16th at 10 a.m. If we were able to accept those 2 dates, I think it would mean that we would be able to get through the presentations.
Sorry, could you just remind us again, Chair?
Thursday the 3rd at 2 p.m., 3rd of June, and Tuesday the 16th of June at 10 a.m. If you can believe that June is almost upon us. It's unbelievable.
But I assume that Ms. Brandon will send out something via email to this country.
Oh, sure. I'm just proposing those dates, and I think we have the DPP, we have the Ministry of National Security, which I expect to be as fulsome as the ones today. Sorry, it's Wednesday, June the 16th.
Wednesday.
Wednesday, June 16th. At 10 a.m. and June the 3rd, which is just to make sure that at 2 p.m., just to make sure that the 3rd of June, again, somebody just check to see what day that is. That Thursday or Tuesday?
Thursday.
It's a Thursday.
Thursday, okay. So Thursday, June 3rd at 2 p.m., Wednesday the 16th at 10 a.m., at which point on the Thursday, June 3rd at 2 p.m., we would have the Ministry of National Security and the DPP's office. I suspect that the date for thing has closed now. Ms. Brandon?
Good morning, Chairman. The date for submission has closed.
So it is fair to say that we will receive and hear four submissions, 2 of which we heard today. Outstanding would be Ministry of National Security and the DPP.
Yes, Chairman. Yes, Chairman.
Well, I had expected more, but the 4 critical ones are in, so that's important, and at least we have given the opportunity, including a extension for other interested parties. So the work has to continue.
Chairman, just to ask, were there any targeted groups that we had requested?
Yes, Ms. Brandon, we had written letters to specific groups. Can you just remind us on the instruction of the committee?
Just give me a minute, Chairman.
Computer Society, quite a few of them, if I recall.
And
Well,
so we would have a.
Just to clarify, sorry, you mentioned Computer Society a while ago. I just want to clarify that our partner here, Stacey Hines, is the president of that society. So you can
pull that one apart.
You can tick off that box.
Yeah, because remember we need several.
Right.
Oh,
is that
okay.
I suspect that was sotto voce.
There was another instruction somewhere else.
Okay. And while I'm speaking here, just as a quick for the Mocha team to do a little further research, because we got into a little tete-a-tete about the definition of security researcher versus ethical hacker. They need to do a little research around the concept and the whole industry of a bug bounty. That's a huge global industry that is happening, and discussions are happening here in Jamaica. That whole industry is around people going around finding bugs in software and then letting the people who write the software know they didn't have any permission, but their intentions are clean. But I said that's for further discussion because it's coming at the tail end of the meeting. But Mocha team need to do a little digging and research around that idea and concept.
Thank you very much. Ms. Brandon, you have the list of names that we wrote to?
Yes, Chairman. So I wrote to the Jamaica Cyber Incidents Response Team, the Communications Department of the Communications Forensic and Cybercrimes Unit of the JCF, JITSA, Jamaica Computer Society, which is now merged with JITSA, yes. The Office of the Director of Public Prosecution, the Jamaican Bar Association, Mocha, Financial Services Commission, SIMTI Limited, PSOJ, and the Jamaican Bar Association.
Surprising that we didn't get responses from some of those critical players.
Yeah, looking at it like a place like Jambar in the scheme of things.
Log, you see the plant beside the mint?
Senator Campbell Rodriguez.
Senator Campbell Rodriguez, we want a piece of that mint tomorrow.
Senator Campbell Rodriguez, careful how you're speaking without the mute. You might get in trouble from this. You might get in trouble from this very committee. We'll start with you today.
Exactly. Mic is now up. Apologies, colleagues.
Yes, Chair. I was asking if there was any of those groups that we really wanted an intervention from, if we could just give them a reminder.
Ms. Brandon, you want to just read them out again so the members have another, they can take note of it and see if there's any specific one that we'd like to reach out to again. I'm surprised about the Bar Association, to be honest with you.
Yes, sir.
The Jamaica Cyber Incidents Response Team from the Ministry of Science, Energy and Technology, Communications Department of the Communications Forensic and Cyber Unit of the Jamaica Constabulary Force, the Jamaica Computer Society, Jamaica Information Technology and Service Alliance, Office of the Director of Public Prosecutions, the Jamaican Bar Association, Mocha, Financial Services Commission, SIMTI Limited, Private Sector Organization of Jamaica, and the Jamaican Bar Association.
The two that jump out on me, member Gail, is the Bar Association and the Financial Service Commission.
FSC, yes.
Yeah.
Yes, Chair.
Those two jump out.
In addition, what we can do is to send them a reminder and ask them for either commitment or a response within a defined period.
Yeah, and the fact is, it can be a written response at this stage.
Right.
In addition to those, Mr. Chairman, I think perhaps we should have invited representatives of academia, University of the West Indies, UTech, NCU. I know they all have very active ICT departments or IT departments. Perhaps they may have had a useful contribution, but at least we should have probably have invited them.
At this stage, Member Bunting, I don't think it would be do us any harm to at least write them and ask for a written response at this point. At least we'll have some input from them when we're finalizing the recommendations. So, Ms. Brandon, we can do that for sure. I would definitively, especially as we said, the Financial Service Commission and the Jamaica Bar Association, and of course, Member Bunting asked for the academia. And the truth is that if we had written them before, we could just write all of who we wrote to before to indicate the deadline has passed. However, if they wish to make written submissions, we are prepared to accept that based on the significance of this particular legislation.
Chairman?
Mm-hmm.
Is there a specific deadline for the committee?
It would have to be by the next meeting, on or before the next meeting.
So that's by June the 3rd.
As a matter of fact, I put it to the end of this month.
Okay, Chairman.
Yeah, members, you concur?
Yes, Chair. There's agreement, Chair.
All right, so we had a good long session today, well worth it. And I think we are at least getting some good input from the presenters so far, and I look forward to Ministry of National Security and most importantly, the DPP, who we could then get into some deeper discussions in relation to the timelines that will be put in relation to getting swift justice in relation to the cybercrime issues that we're proposing to amend. So thank you very much. It has been a very informative meeting and look forward to the next meeting on the 3rd, June 3rd at 2 p.m. Until then, keep safe and God bless you.
Same to you, Minister.
All the best.
Thank you, Chair. Keep safe.
Thank you.
Take care, everyone.